Can you hear me now? Awesome. So we'll get this round started in just a moment. I'm going to introduce the judges, and then we should be good to start the round. Let's see, let me just make sure all the judges are here. Yes, all the judges are here, great. All right, our first judge is David Summers. David Summers is an NCFCA alumnus of 5 years who competed in team policy, served as a club team policy captain 1 year, and competed in regionals on multiple occasions. He is currently a senior at the University of Texas at San Antonio, but is taking some time off between finishing his bachelor's in 2023 by completing missionary school training with the organization Youth with a Mission. After he graduates from University of Texas at San Antonio, he hopes to attend law school at the University of Texas, Austin. Thank you so much, David, for taking the time to judge today. Our second judge is Tyler Olin. Tyler, also an NCFCA team policy alumnus, graduated from Howard Payne University. During his time at Howard Payne University, Tyler competed on several debate teams and consistently reached semifinals, and was a parliamentary debate finalist. After graduating, Tyler worked on suicide watch at a children's hospital before starting his current job as a CPS investigator. Thank you so much, Tyler, for your valuable time today. And last but certainly not least, we have our judge, Isaac Summers. Isaac, also an NCFCA alumnus, also graduated from Howard Payne University and was a roommate with Tyler while they were both there. Isaac graduated from Harvard Law School in 2021, is the founder of Ziggy Online Debate, runs a one-man consulting shop helping prospective law and grad school students apply for educational programs, and is currently working as a law clerk for a federal district court judge in Texas. Isaac will be moving to DC later this fall to work at a law firm there. Thank you, Isaac, and thank you so much to all of our judges.
Yes, thank you all judges so much for being here today, Tyler and David. Definitely appreciate you taking the time. Debaters, we'll hand it off to y'all to get things started. Congratulations to both teams, and we're looking forward to a great round.
I will echo those words. We really are thankful for all of y'all. Thank you, Isaac, for running this whole thing, and thank you all of y'all for taking your time to judge. And once again, congratulations to the negative speakers. Looks like everyone's ready, so we can go ahead and begin introductions. My name is Justice Aryani. I'll be the first affirmative speaker in today's debate round.
I'm Cyrus Aryani, and I'll be the second affirmative speaker. I'll echo what everybody's already said. Thank you, all of our valuable judges, for taking your time.
Hello, my name is Anna Say. I'll be the first negative speaker. Thank you again for all of your time as judges, and congratulations to the affirmative team.
And that leaves me, Luke Brooker, and I'll be the second negative speaker tonight. Thank you guys so much for making this possible.
Wonderful. I'm going to go ahead and get an 8-minute timer for this first affirmative constructive. For clarity's sake, we'll reintroduce ourselves before each speech, just so that we're able to ascertain who is who. All right, I've gone ahead and set 8 minutes on my timer. Looks like everyone's ready. So I'll go ahead and get started. Farron Claiborne and Terrence Richardson were found not guilty of murder. In fact, the prosecution had no case. As per ABC News, there was no DNA, no fingerprints, nothing to connect them with the crime. They didn't even match the description of the perpetrators. One of the members of the jury later recalled, quote, "We knew they weren't guilty of this murder," end quote. But even so, Claiborne and Richardson were sentenced to life in prison. The jury said they were innocent, the evidence said they were innocent, but they were sentenced as though they were guilty. One might think that these individuals are victims of an abusive regime and live in either a dystopian novel or authoritarian state. But they don't. They are Americans, and they are victims of the American status quo. It's because my partner and I believe that the integrity of the jury's verdict is foundational to a fair criminal justice system that we stand resolved. The United States federal government should significantly reform its policies regarding convicted prisoners under federal jurisdiction. We'll begin with two definitions. Definition 1 you can write down as a convicted prisoner. Once again, a convicted prisoner. Someone that is convicted is someone who has been found guilty by a jury of at least a single crime. Additionally, the legal definition of a prisoner that has been used in multiple United States court cases and as published by Black's Law Dictionary is, quote, "one who is deprived of his liberty, who is against his will, kept in confinement or custody," end quote. Simply, if someone has been convicted of a crime and is being restrained, whether in a prison or a courtroom, they are within today's resolution because they are legally considered a convicted prisoner. This brings us to definition 2. You can write definition 2 down as acquitted conduct sentencing. Once again, acquitted conduct sentencing, or ACS for short. After a defendant has been found guilty of at least a single crime, he is brought before a sentencing judge who will sentence him for the crime he's guilty of. Right? Well, actually no. According to the Cato Institute in 2019, acquitted conduct sentencing is when a judge sentences a defendant for charges of which the jury found him guilty of, and also for charges of which the jury explicitly found him not guilty of. For example, let's say I'm on trial for murder. They happen to find me guilty of, say, a small amount of cocaine offense. However, they find me not guilty of murder. Let's say the judge in my case ignored the jury's acquittal and sentenced me for murder anyways. Now, instead of forgetting a few extra years, I'm in prison for the rest of my life. Sounds fanciful, right? Well, in the words of a Santa Clara Law Review, quote, "This is jurisprudence reminiscent of Alice in Wonderland," end quote. In actuality, however, it happens all the time, not in fiction, but in the real world. And not just in the real world, but in America. In fact, this hypothetical is exactly what happened to Claiborne and Richardson. As explained by the Americans for Prosperity Foundation, acquitted conduct sentencing, quote, "allows judges to punish people for conduct a jury found them not guilty of," end quote. Our entire criminal justice system is based on the idea that a jury determines your legal guilt or your legal innocence, yet a single judge can throw all of that out the window. The National Association of Criminal Defense Lawyers and 3 additional groups published a report in June of 2021, explaining that, quote, "virtually all academic commentators conclude that acquitted conduct sentencing does not reflect sound sentencing policy, makes no sense as a matter of law or logic, and is a perversion of our system of justice," end quote. At this point, you're likely thinking, sure, Justice, it might actually sound bad, but how often is it actually used? This brings me to my first fact. My first fact you can write down as it's a widespread practice. Once again, it's a widespread practice. Amy Barron Evans has her JD from Harvard, and along with JD Jennifer Niles, wrote that, quote, "judges are required to calculate the guidelines range based on separate crimes of which the defendant was acquitted. The commission advises judges to find these crimes by preponderance of the information without regard to the rules of evidence. The guideline range is then increased by the same number of months or years as if the defendant had been convicted. These provisions were not authorized by Congress and were adopted without empirical support," end quote. What this evidence provides is that judges are required to factor acquitted conduct into the guideline calculation as long as they are 50.01% sure that it actually happened. When they do so, acquitted conduct is punished exactly as if the jury had convicted the defendant. In short, the jury's verdict is rendered meaningless. As a result, J.D. Mark Holden wrote in September of 2019 that, quote, "judges routinely use acquitted conduct sentencing to increase prison time," end quote. Additionally, according to 4 additional lawyers in June of 2021, they wrote that, quote, "sentences are enhanced by acquitted conduct with troubling frequency and across a range of cases. In a disturbing number of cases, defendants acquitted of murder have been sentenced as though they were convicted of taking a life," end quote. I'd like to say those words again. Defendants found not guilty of murder were sentenced as though they were found guilty. My partner and I have a simple question that we present to both all you 3 judges as well as the negative team. Is that what justice should look like? If the answer to that question is no, the goal of the criminal justice system is failed by our current system and an affirmative ballot is warranted. Shenna O'Toole, defense attorney and president of the Due Process Institute, found in 2021 that, quote, "we must look to Congress for a remedy," end quote. Because I agree. Sentencing people for crimes a jury found them explicitly not guilty of is a bad idea. We represent the plan. Enforced by Congress, the President, and Sentencing Commission, and amended upon an affirmative ballot are 2 mandates. Mandate 1 you can write down as a federal court of the United States shall not consider acquitted conduct while sentencing a convicted prisoner. Mandate 2 is very similar. The federal sentencing guidelines shall prohibit judges from factoring in acquitted conduct while sentencing convicted prisoners. Any unforeseen costs will be funded through normal means. But what this means in plain language is that when judges determine sentences for convicted prisoners, they are barred from using acquitted conduct to increase the length of a sentence. To sum it up in a sentence, we ensure that a not guilty verdict actually means not guilty. With the plan out of the way, we must examine the justification for ending this practice and its resulting effect. I think the resulting effect is very simple, and you can write it down as it's ending an unjust practice. Once again, ending a fundamentally unjust practice. Logic clearly tells us if you're found not guilty at trial, you won't be punished for the crime you're found not guilty of. However, this isn't just Cyrus and I's logic. Rather, according to the Americans for Prosperity Foundation, quote, acquitted conduct sentencing is unjust and unfair to defendants. It is unfair to juries, undermines legitimacy of our criminal justice system, and is bad sentencing policy, end quote. In testimony before the Supreme Court in 2021, it found that, quote, it stands our criminal justice system on its head to hold that even a single extra day of imprisonment can be imposed for a crime the jury says the defendant did not commit, end quote. Sentencing people for crimes that they were explicitly found not guilty of is unjust, but will judges actually stop using it under our plan? Well, I point you to the words of the American Bar Association, as found on September 9th of 2015. They found that, quote, a congressional enactment to the sentencing guidelines that simply forbade sentencing a defendant on acquitted conduct would solve the issue prospectively, end quote. I'd ask you to do just that. The words of the Real Clear Policy Institute in 2021 define the affirmative position. Quote, no matter how it happens, all Americans should agree that acquitted conduct sentencing must end, end quote. There is one thing that 84% of sentencing judges, all foreign common law countries, all of our states, several Supreme Court justices, and nearly every advocacy group commenting on this issue agree on. Not guilty does, in actual practical fact, mean not guilty. If you agree with that, I'd ask you to right America's wrongs and protect the jury's verdict by voting affirmative. Thank you. I'm now ready for any questions that the negative team might have.
Hi, Justice. Can I have a copy of your 1AC?
Sure, I'll have my partner send that right over.
Awesome. Is the purpose of a jury to achieve justice?
The purpose of the jury is, in legal sense, it's to find a defendant guilty or not guilty. There might be a case in which a jury, at a pure technical level doesn't administer justice, but the job of the jury is to administer a guilty verdict or not guilty verdict.
Okay, so there might be a case in which they don't achieve justice.
In our criminal justice system, the result of the jury trial is considered, in our criminal justice system, justice. That is the administration of justice.
Okay, so a jury always achieves justice. Is that your contention?
My contention is that, sure, there might be a couple cases in which the jury got it wrong per se. However, in the American criminal justice system, the result of the jury's trial is the administration of justice.
Okay. How often has acquitted conduct sentencing occurred?
So the government doesn't track those statistics simply because they just don't collect those statistics. However, the evidence I read said it's routinely used and it's frequently reoccurring. There is Douglas A. Berman, who's a professor of constitutional law, found that it's added about tens of thousands of years of prison time onto sentences.
Okay,
However,
so we're using frequently used and routinely used. How do those people know that if there's absolutely no data on this?
What I said is the government doesn't track those statistics. That doesn't mean that a lawyer or people with expert in the area, such as Supreme Court clerks, as well as additional lawyers and professors of constitutional law, that doesn't stop them from looking in at exact court cases and determining the reasoning for the factoring of the sentences. So the experts in this field determine that it's routinely used. It's added tens of thousands of years onto sentences.
Okay. Are judges required to use acquitted conduct sentencing?
So under the guidelines, the guidelines aren't legally binding, however, they are used in the vast majority of cases, they are required to consider acquitted conduct when it comes into play. For example,
right. They're required to consider, just to clarify, right?
In a legal context, consider means legally factor in. For example, in one court case, a judge didn't use acquitted conduct sentencing, and he had his entire court case overturned because he failed to use it.
Okay, can you bring that up in the round just so we can be all clear on those details in particular? But also, so is it your contention that judges must use acquitted conduct sentencing if it's applicable, even though these guidelines, as you say, are advisory pursuant to United States versus Booker?
Like I said, they are legally advisory. However, judges, in practically all cases, abide by them with the force as if they were law. In a sense, de facto mandatory. So under that sense, yes, it is required under the advisory guidelines.
Right, but they're voluntarily abiding by them.
Well, that's not the case, because if a judge was, like I said, if a judge was to not use the guidelines, not enforce the guidelines, their sentence will be overturned by an appellate court, as has happened in the past.
Okay, and I got one final question. So is it fair to characterize the affirmative team's stance that the jury is being silenced because of acquitted conduct sentencing?
That's like a specific portion of it. Rather, what we're saying is not guilty is not being preserved as not guilty.
That's fair. Thank you so much for your time.
We'll start our 5 minutes of prep time now. All right, no further prep time is necessary. We have 4 minutes and 11 seconds on the clock. The affirmative team has provided us today a very convincing case. No one in this room wants to see someone who's innocent go to jail for a crime that they didn't commit. But here's what I want to clarify today in my speech. It's not as black and white as that picture. It's much more nuanced, and I think there is a place for those small instances, those rare cases in which juries do get it wrong. And in that case, it's worth it for judges to use acquitted conduct sentencing to uphold the true meaning of justice, which is giving each man his due. Today, I want to walk through 2 main points of significance and provide a disadvantage to the proposed policy. But before I get into all of that, I want to start with a clarification, and that is the burden of proof. You can write this down as proving a problem and a benefit. This is the standard and the challenge I would give the affirmative team today. Like in every team policy debate round, if the affirmative team does not uphold this with their policy and prove these 2 things for you today, then they do not warrant your ballot. So with that in mind, I want to get into my first point of significance, really why the problem isn't as bad as the affirmative team would have you believe. You can write this down as rarely used. And I'm going to have a couple of subpoints to explain what I mean by this, because as you heard in cross-examination and in the first speech of the affirmative team, they have some rough opinions from qualified individuals, but we never heard specific statistics. And so I want to give those to you today. You can write down my first subpoint as 79,000 federal cases. This is according to the United States courts accessed or published rather in 2018. That's the rough amount of cases we have in the federal system. So how many times is acquitted conduct sentencing used? Well, that's my second subpoint. You can write this down as minuscule percentage. We've done the math, and given that there are about 32 acquitted conduct cases every year, that boils down to 0.04 of all federal cases actually being required or involved in acquitted conduct sentencing. That's almost nothing. And so we need to keep in the back of our mind that while this is a tool used by judges, it's used rarely and really only when it's necessary. Leading me to my second overall significance point. You can write this down as perfectly constitutional. Now, the affirmative team seems to insinuate that since we're stepping somehow on the role of the jury, it's the jurisdiction of the courts to look at this problem and to hopefully solve it. Because if the affirmative team's argument about juries is correct, that we're somehow infringing on this right, why hasn't it been struck down by the Supreme Court or any other court of appeals? The answer to that is very nuanced, leading to my first subpoint. Watts greenlit acquitted conduct sentencing, or ACS. Watts is the name of a specific court case, and I'd like to read to you from that Supreme Court decision decided in 1997. Here's what the Supreme Court says, quote, "A jury's verdict of acquittal does not prevent a sentencing court from considering conduct underlying the acquitted charge, so long as that conduct has been proven by preponderance of the evidence. This court has held that consideration of information about a defendant's character and conduct at sentencing does not result in any punishment for the offense other than that for the crime of conviction," end quote. So what's happening with acquitted conduct sentencing and what the Supreme Court's logic here is that while people are to some extent having their sentences increased based on acquitted charges, those increases aren't for a separate charge of their own. And that's a really important legal distinction, leading to my second response, or second subpoint rather, cases repeatedly refused. If we actually look at the number of times this issue of acquitted conduct has made it to the Supreme Court and lawyers have petitioned them to hear this case, it's quite lengthy. And every single time the Supreme Court rather has pointed back to that decision in 1997 in United States versus Watts, where the Supreme Court held that acquitted conduct sentencing was okay with a couple of nuances. According to a government brief filed in opposition to granting certiorari to the case of Vincent Asaro argued in 2019, the Supreme Court has repeatedly and recently denied petitions for writs of certiorari challenging the reliance on acquitted conduct at sentencing. It then goes on to list a litany of cases, even very recent ones, in which lawyers have petitioned the Supreme Court to hear this issue on the issue of juries, and the Supreme Court has specifically refused. That's an important note. The Supreme Court has looked at all of the legal and moral arguments for this, and they've still decided to keep with the current system. That sends a powerful signal. And I want to get into why, really in my one main disadvantage. This could perhaps be the most important point in all of today's debate round. And you can write it down as this: eliminate a necessary tool for justice. Now, it's important to go back to cross-examination, where the affirmative speaker basically conceded that sometimes it's possible that hypothetically a jury could get it wrong. I'm not saying that's the majority of the time, but there is a possibility that a human jury can get something wrong, in which a miscarriage of justice would actually be carried out if the judge did not use acquitted conduct sentencing. So let me give you an example of one of those cases. You can write down my set point as Vincent Asaro. This is a fairly recent example of someone who was charged with a crime, and the judge used acquitted conduct sentencing with that crime to increase the sentence for a very just cause. This is according to the government brief filed in opposition to granting certiorari to that case of Vincent Asaro, argued in 2019. And here's how they describe it. They say, quote, "The government requested an above guideline sentence of at least 15 years of imprisonment based on petitioner's lifelong allegiance to a dangerous criminal organization, his extensive participation in heinous criminal acts, including murder, and the nature of the charged crime in arson he directed as a result of a road rage. This man, Vincent Asaro, was such a profoundly dangerous monster, they made a movie about him. And they made a movie about all of the murders that he had organized through his participation in a family mob ring near the New York area. This man did deserve extra time in prison. There would have been a miscarriage of justice had the judge not used acquitted conduct sentencing. Is that the majority of cases? Probably not. That's why it's not used regularly, but it is an important tool. Leading to my second subpoint, hinders informed sentencing. I want to read to you an opinion from a Supreme Court justice in the court case of United States or Apprendi versus New Jersey. This is a court case looking at this issue of acquitted conduct sentencing. And here's what it says about the judge's ability to use this. Quote, "Nothing in this history suggests that it is impermissible for judges to exercise discretion, taking into consideration various factors relating to both offense and offender in imposing a judgment within the range prescribed by statute," end quote. So what the Supreme Court has said thus far is that judges do have discretion to be able to do this when it is just. Leading to my third and final subpoint, inhibiting fight of organized crime. According to a case law database from the United Nations in 2020, talking about the Asaro case, they say that because of acquitted conduct sentencing and considering acquitted conduct, it can be an important tool in executing long-term prison sentences for members of organized criminal groups, end quote. That's the direct quote from a very legitimate agency talking about this. Should acquitted conduct sentencing be used in the majority of cases? Absolutely not. But is it a necessary tool? Yes, and that's why I'd urge you to vote negative and stick with the current system. Thanks.
Alrighty, I'm gonna go ahead and get a timer for this 3-minute cross-examination. Alright, I've got 3 minutes on my timer if you can confirm.
Yes.
Wonderful. I'll go ahead and get started. Great speech. Naturally, I've got a few questions for you. First off, is justice quantifiable?
It is in the vast majority of cases. I think trends and statistics are helpful, however, in seeing how big a problem it is.
Okay, and could we have your statistics or any number that points to 32 a year being the case? If you could send that over, that would be great.
Sure, I can go ahead and send it over.
Wonderful. And we can agree, both sides in today's debate round agree that acquitted conduct sentencing is perfectly legal.
Yes.
Okay, I'm glad we can agree on that. And you would agree in the case of Watts v. United States, they didn't endorse the practice, and even the federal district court cases. They never have endorsed the practice, rather they have found that courts may rely on it, as in it doesn't bring into a constitutional issue into hand, as in it's legal.
So you're technically correct. If you read the decision of Watts, yes, it doesn't endorse it, but it is very significant that all of the petitions of certiorari for lawyers to actually hear cases or the Supreme Court to hear cases on the subject have all been denied. And there's a litany of those cases.
Right, and you would agree that typically the reasoning that's cited in all of those cases is typically, once again, this one case of Watts v. United States, where the Supreme Court did find it as a legal practice, one that does not violate the Constitution.
Right, and it is notable that the Supreme Court justices do use that as the top precedent.
Okay, I'm glad we can agree on that. And is something that is constitutional or something that's legal, is that a good thing?
Does legality necessitate something being just? Is that what you're asking?
I'm just asking if a constitutional policy is a good one.
Generally, they are.
Okay, interesting. You talked a little bit about how the you talked a little bit about these two different examples. You quoted the UN, and then you also talked about one gang member. If we could see those cards, both from the UN and the cards referring to the gang member, that would be wonderful. And in those cases, was that gang member actually charged and brought before a jury about any of those crimes?
Yes, he was, to my knowledge. I have a specific card of evidence going through all the details of the case if you'd like to see that.
Okay, so he was brought before a jury.
Yes.
And do you have any evidence saying or any cited reasoning or holding upon acquitted conduct sentencing as the justification for the sentence later imposed?
Yes, it does. The specific part I read from the card goes through all of the reasons as to why it would be just for him to get an extra 15 years.
Okay, if we could see that piece of evidence, once again, that'd be wonderful. Now, in your words, what is the job of the judge?
The job of the judge is to make sure that criminals get just sentences.
Okay, but you would agree in a legal sense, the job of the judge is to sentence someone based on the jury's conviction. As in, the jury convicted someone, the judge's now job is to sentence someone.
In those cases, yes. However, in other areas, we do give judges discretion as to whether to limit or increase the amount of time they're going to put on someone's prison sentence in proportion to the crime.
Okay, it looks like I'm out of time. Thank you so much for your answers. We're gonna go ahead and take some prep time to look at that evidence.
All right, I've just stopped our prep time at 2 minutes and 20 seconds. This is an 8-minute speech. So 8 minutes on that timer. If all of my judges are ready, I'll go ahead and assume that you are, and I'll start that timer. Judge David Viviano, in his concurring opinion of People versus Beck, a case decided in July 2019, wrote, quote, "In every criminal trial, jurors are instructed. What you decide about any fact in this case is final. But if a judge may increase the defendant's sentence beyond what the jury verdict authorizes, a more accurate instruction would read, what you decide about any fact in this case is interesting, but the court is always free to disregard it. Unquote. This, in a sentence, is the thesis of the affirmative team, that the verdict of a constitutionally enshrined jury trial is not just interesting, it should be final. Yet in the status quo, that is not the case. The verdict of the jury is routinely ignored. A system that allows such a result is perverse, illogical, and unfair, and thus must be reformed. In today's speech, I'm going to go ahead and respond to all of the negative argumentation. Let's go ahead and look at the first argument. The first argument and clarification that the negative team made was that of the burden of proof. I'd like to make one clarification in that regard. The goal of the affirmative team is to make the world a better place. So in today's round, we have to prove that our benefit of our policy outweighs the costs. That's the goal of today's round. Her first point was that it is rarely used. Once again, rarely used. Her point under significance was simply that there are only 32 cases a year. Now I have one problem with this statistic. Now this statistic relied on one statistic that basically said that in a couple years, 760 times acquitted conduct was used within those years, in that period of time. And based on that calculation, they looked at the total amount of trials that have gone through in the federal system and then calculated that number. But the evidence that talks about 760 happening every single year, or excuse me, 760 happening over a period of year, only refers on how many times the court relied on United States versus Watts. It does not denote the exact wording acquitted conduct sentencing. A court can rely on Watts and the opposite thesis of what Watts actually cited. Any court can cite Watts as a part of the case. It does not necessitate that acquitted conduct sentencing was used. While Watts did rule on acquitted conduct sentencing, simply the keyword Watts in a decision does not necessitate that acquitted conduct sentencing was in. Courts can decide on acquitted conduct sentencing without even referencing Watts in the first place. Thus, the statistic would necessarily be skewed. Ian Knopf, a professor of constitutional law, wrote in the Tennessee Law Review in 2009 that, quote, what could instill more confusion and disrespect than finding out that you will be sentenced to extra years in prison for the alleged crimes of which you were acquitted? The law would have gone from something venerable and respected to a farce and a sham, unquote. Acquitted conduct sentencing affects people. It doesn't just affect people, it affects people in a significant way. In fact, professors of law, Pamela Carlin and Leah Lippman, wrote alongside Free Lawyers in 2018, quote, judicial reliance on acquitted conduct is important, frequently reoccurring, and a troubling contradiction in sentencing law. This phenomenon occurs across the full range of criminal cases. Douglas A. Berman, a professor of law, found that in January 2022 that, quote, I suspect tens of thousands of year federal prison time has been imposed based on acquitted conduct, unquote. Acquitted conduct happens a lot. Not just a couple people, it happens quite often in a disproportionate and significant manner. Ultimately, acquitted conduct affects a lot of people. And even if it was to affect just 32 people a year, that's significant in and of itself. These people are having time added onto their sentence based off things that they were found not guilty of by a constitutional jury. Even if that was the case, it's important. If slavery affected 20 people, we should end it. While acquitted conduct sentencing may not be the exact same thing as slavery, it's still heinous and it needs to be ended. We should reform acquitted conduct sentencing because it's significant. Her next 2 points talked about the constitutionality of acquitted conduct sentencing. She brought up points about talking about how United States versus Watson, all of these different upper case laws support the use of acquitted conduct sentencing. You can time my response as bad policy. Once again, bad policy. The ruling and what we're debating today is not whether or not acquitted conduct sentencing is necessarily legal. If it wasn't legal, we wouldn't be debating here. The Supreme Court would have overturned acquitted conduct sentencing, and there would be no debate because it would be illegal. What we are saying is that acquitted conduct sentencing is unjust, and it's also just a bad policy, therefore it thus should be reformed. All of the Supreme Court citing of the United States versus Watts endorsed only one thing, that acquitted conduct sentencing technically gives a jury trial, and that's all that's guaranteed by the Constitution. What we're arguing is the purpose of that jury trial. The effect of that jury trial is being ignored by the sentencing judge, and that is a bad thing, and that should be reformed. Her next point was that of how it's an important tool, or how acquitted conduct sentencing is essential if a jury gets it wrong. Now, first, I'd like to argue one point, and that is, even if the jury was to get it wrong, we shouldn't abolish, or excuse me, we should abolish acquitted conduct sentencing. Even I would concede if there were a couple cases in where the jury was to get it wrong, that doesn't mean the judge should have the power in every single case, to use acquitted conduct sentencing. Acquitted conduct sentencing is absolutely heinous in the way that it's applied. And even if the jury got it wrong, it doesn't matter. We shouldn't have a bad policy just because there are a couple exceptions and where the jury got it wrong. Now, I do want to look at the case and the evidence that they talked about how the UN basically endorsed the use of acquitted conduct sentencing. Now, nowhere in the evidence does the UN actually endorse the practice. They're simply explaining what acquitted conduct sentencing is. There's no language or rhetoric that endorses it, it's simply an explanation of what the practice is. They also brought up an example of this person who was really bad and he got sentenced through acquitted conduct sentencing, and they basically saved the day. Well, I mean, there's many alternatives. You don't have to use acquitted conduct sentencing. There could have been a retrial if there wasn't enough evidence. But it also proves the point, if there isn't enough evidence to sentence someone, you shouldn't sentence someone. If there wasn't enough evidence to sentence this person based off the supposed murders that he committed, well, he shouldn't have been sentenced. That's how our criminal justice system works. Just because there's a lot of media reports about this person doing something, you need to have actual evidence to sentence it. And taking down the burden of proof of evidence down to only 50.1%, it's heinous and it should not exist in our current system. Now, they talked about how judicial discretion will be harmed by the banning of acquitted conduct sentencing. You can tell my response is exactly the opposite. Discretion is harmed by acquitted conduct sentencing. This is according to Claire Murray, Assistant Attorney General for St. John's Law Review in 2010. Quote, the guidelines' mechanistic imposition of a sentence predicated on prior acquitted conduct is the antithesis of the case-by-case approach, unquote. The guidelines themselves, the imposition of a sentence predicated on prior acquitted conduct is the antithesis of a case-by-case approach. Ultimately, acquitted conduct sentencing only harms judge discretion. And if we allow acquitted conduct sentencing to be banned, judges will still have all of the other relevant conduct they can use. It's another note I'd like to make. We're not ending relevant facts or relevant conduct. The only thing the affirmative team is ending are specific facts the jury said you were not guilty of. Those things you cannot be sentenced on. Any other facts that were not found by the jury or weren't presented to the jury, those can be used. Past criminal history. That's not outlawed by the affirmative team. Thus, all this jury discretion or all the judge discretion will not necessarily be ended by the affirmative team. In conclusion, I want to look at the support that acquitted conduct sentencing, the banning of acquitted conduct sentencing has. Ethics Alarmist, September 28th of 2019, said, quote, the Cato Institute, Americans for Prosperity, the American Conservative Union, Americans for Tax Reform, Freedom Works, Prison Fellowship, the R Street Institute, Right on Crime, and Koch Industries, among other activists and professional groups from the right and left of the political spectrum, support it. Unquote. Ending acquitted conduct sentencing is not a partisan issue. Ending the practice of putting people in prison and adding significant portions of time into people's sentences based off crimes they were found not guilty of by our constitutional jury denies the proper role of a jury as found by the Cato Institute. Ultimately, acquitted conduct sentencing must end, and you have the authority to do it. Thank you.
All right, 3 minutes. Hi, Cyrus. So first off, would you agree that in order to win today's debate round, you have to prove an advantage over the current system?
Correct. That's the benefit I was talking about.
Okay.
We need to benefit the world.
Do you have any more details surrounding the examples you brought up at the beginning of your 1AC?
Are you talking about the opening quote about this person? That wasn't an example per se. That was just him saying in a criminal case, if the jurors are instructed, what you decide about any.
Oh no, the beginning of the 1AC. Pardon me.
Oh, the 1AC. Yes, we do have a document talking about the facts of that case. We can send it to you if you like.
Okay. If you could send over the facts of the case, that would be wonderful. How often is acquitted conduct sentencing used statistically?
Statistically, well, since the government does not track the number, there's no way to know. However, Douglas A. Berman did a calculation based on the data he was able to get from third parties, and that was about tens of thousands of years added on the people's sentences.
Okay. Now, has the case of United States versus Watts ever been cited in a non-acquitted conduct sentencing case?
I haven't gone through every single case, so I can't say that. I don't know.
Okay, but the court case, United States versus Watts, is dealing with acquitted conduct, correct? That's the main question.
The ruling of that case pertained to acquitted conduct sentencing.
Okay.
But
is there any proof? Go ahead.
I apologize. It does not necessitate that every single case that deals with acquitted conduct sentencing has to say Watts in the decision, because that's how they calculated that number.
Is there any standard of proof that needs to be met to use acquitted conduct sentencing as a judge?
Yes. 50, if the respondents ever standard, 50.1%, over 50%.
Okay. Do we use that standard for any other sentencing enhancements?
Yes. In civil cases, that is used. In criminal cases, we only use beyond a reasonable doubt, 99%.
Can you increase sentences in a criminal case as a sentencing enhancement based on a preponderance of evidence?
Only with acquitted conduct sentencing.
Acquitted conduct sentencing is the only one, just to be clear.
acquitted conduct sentencing, relevant conduct, you can probably use that standard, but that's only for the judge. What we're saying is that acquitted conduct sentencing is bad because we are proven beyond a reasonable doubt that it didn't happen or there was not enough evidence to prove it. We're just saying that the downgraded burden of proof is inappropriate.
So just to be clear, there is no other issue or sentencing enhancement that you can use a preponderance of evidence for in a criminal case. Is that your argument?
I mentioned that there were other ones like relevant conduct, other kinds of conduct the judge can use. However, that we're not arguing that relevant conduct is bad.
Okay. Now, are guidelines advisory, or is the use of acquitted conduct sentencing an advisory for judges?
That's actually a good question. So technically speaking, they're technically advisory. However, an appellate court must overturn any decision that goes outside of the guideline, meaning that if you were to pass our plan, appellate courts will enforce it. So it's basically mandatory. I mean, you can
Could
make
you
a
pass
decision
us
outside.
back any evidence you have about appellate courts enforcing that?
Yes,
That would
absolutely.
be wonderful. Thank you.
All right, and for clarity's sake, the facts of the case on Claiborne and Richardson, those are in the appendix of the 1AC.
Okay, I've already looked at those. Do you have any more details?
Other than those, I don't have any with me.
Okay, thank you.
We won't be taking any prep time. So with that said, I have my clock set at 8 minutes, and I'll go ahead and start my speech. In G.K. Chesterton's famous analogy, two individuals walk up to a fence in the middle of an open field. The first individual looks at the fence and says, "There's no reason for this. Let's tear it down." The second individual walks up to the fence and says, "Wait a minute. Before we tear down this fence, let's first understand why it was built." In this debate round, the negative team is playing the role of that second individual. We want to demonstrate to you the reason why acquitted conduct sentencing was built. Because admittedly, when you look at the selective facts that the affirmative team has provided you, acquitted conduct sentencing can look a little unjust. But when we dive into the nuance of the situation, how judges are actually limited in the ways that they can use acquitted conduct sentencing, how and when acquitted conduct sentencing is actually used, we see quite the opposite. That acquitted conduct sentencing is a necessary tool for justice, and it's used in the rarest of cases in a manner that promotes justice. I want to demonstrate this as I respond to the affirmative team's first speech and really show you how they have not upheld their burden of proof. They have not shown you, one, that there's a quantifiable harm in the current system, and secondly, that their plan will actually fix that harm in a tangible way. I want to start off with two clarifications. The first clarification is a direct response to the opener that they read in their 1AC about Mr. Richardson and Mr. Claiborne. My response is oversimplified. Oversimplified. The facts that they provided in the 1AC regarding this case were not from an actual case. They were from ABC News reporting on the case, and they were grossly oversimplified. It was selectively cut parts of that case. But if you actually look at that actual case, it's a lot less cut and dry than the affirmative team is making it out to be. Essentially, what happened is three individuals walked into the woods with a police officer. Those three individuals walked out of the woods. The police officer didn't, leading to believe that based on a preponderance of evidence, it was pretty clear that some murder happened in those woods. Maybe it wasn't beyond a reasonable doubt, but that demonstrates why acquitted conduct sentencing is so essential, and we'll get into that later. But just to clarify, these examples that the affirmative team are bringing up are a little bit oversimplified. But my second clarification is based on a preponderance of evidence. Based on a preponderance of evidence, as was elucidated in cross-examination, acquitted conduct sentencing can only be used when it's based on a preponderance of evidence, meaning that it's more likely than not that an individual did commit that particular set of conduct. Now, the affirmative team said something that was absolutely wrong in the last cross-examination, and then he did later walk it back. But he initially said that acquitted conduct sentencing is the only time the preponderance of evidence standard is used. That's actually false. Whenever we are creating someone's sentence and we want to find a fact, whether that's relevant conduct, whether the defendant used a firearm in the commission of offense, that is always proved by a preponderance of evidence. In other words, this is the gold constitutional standard for sentencing. This was clarified by the Supreme Court in McMillan versus Pennsylvania, where they said, quote, "We have little difficulty concluding that in this case, the preponderance of evidence standard satisfies due process," end quote. So that's an important clarification. This preponderance of evidence standards is something that's used in criminal law to sentence defendants regularly. It's not something special for acquitted conduct sentencing, and it certainly does not subvert justice. I want to get into my response to their fact that they brought up in their 1AC about widespread practice. My response is only used to promote justice. Only used to promote justice. I have two subpoints. The first is 0.04%. 0.04%. Anna will get into some more specific responses to his critique of our numbers, but acquitted conduct sentencing is only used in 0.04% of cases. That means that it's only used in the rarest of circumstances when it's absolutely necessary. Now, the affirmative team has contended that, well, judges have to use acquitted conduct sentencing. They must use it. That's false. My subpoint B is not required to use acquitted conduct. Not required to use acquitted conduct. I will admit that judges are required to consider acquitted conduct sentencing, and that's exactly what all their evidence has said. However, judges are in no way required to use acquitted conduct at sentencing, because as we've all agreed in this round, pursuant to the court case of United States versus Booker, those guidelines that the judges are using and acquitted conduct are all completely advisory, meaning that judges can use acquitted conduct, but they are under no obligation to use it. And the impact of this argument is a challenge to the affirmative team. Prove abuse. Once again, that's prove abuse. Because acquitted conduct sentencing, it does not have to be used in every case. And because it's used in such few cases, they need to prove a tangible abuse, not through selective pieces of evidence, but an actual proof of abuse. Because from what we know in the current system, acquitted conduct sentencing is used in a wise manner. And I want to further expound upon this as I respond to their justification, where they argued that they were ending an unjust practice. And really the tenor of the entire affirmative team's argumentation is that juries are being disrespected. So my response here is that jury verdicts are respected. Jury verdicts are respected. Now, if juries were being completely ignored and say someone who was convicted of smuggling cocaine but acquitted of murder was getting a sentence as if they had been convicted of murder or for that murder specifically, that would be unjust. But that's not what's happening. Let's look at my first subpoint. Punishment authorized within jury authorized range. Punishment authorized within jury authorized range. When a jury convicts an individual of a crime, say for smuggling cocaine, they'll authorize a range of, say, 5 to 40 years. In other words, the jury approves a punishment anywhere between that 5 and 40-year range. And so now it's the judge's job to use all the facts that he can to make a just sentence within that range. And acquitted conduct sentencing can only be used in that range that the defendant is convicted of. In other words, that cocaine charge, not the murder charge. This was clarified by the court case of Elaine versus United States in 2013. The Supreme Court said, quote, juries must find any facts that increase either the statutory maximum or minimum, because the Sixth Amendment applies where a finding of fact both alters the legally prescribed range and does so in a way that aggravates the penalty. Importantly, this is distinct from fact finding used to guide judicial discretion in selecting a punishment within fixed limits of law. While such findings of fact may lead judges to select sentences that are more severe than the ones that they would have selected without those facts, the Sixth Amendment does not govern that element of sentencing. End quote. This quote is crucial for a couple of reasons. First, it identifies a limit on acquitted conduct sentencing being used. It can only be used to punish someone for the crime that they are found guilty of by a jury. But secondly, this is the Supreme Court specifically saying that using facts like acquitted conduct specifically aligns with the Sixth Amendment. Now, the affirmative team tried to eschew this in the last speech and say, well, we agree that it's constitutional, but it's not a good policy. But hold on a minute. Their entire argument for this round is that juries are being disrespected. If juries were really being disrespected, wouldn't we have a constitutional issue here? We literally have that in the Sixth Amendment of our Constitution, and yet the Supreme Court has been very clear on this issue. This is not a problem with disrespecting juries. And I want to elucidate that through my second subpoint. Judicial discretion within authorized range is prudent. Judicial discretion within authorized range is prudent. Now, the affirmative team has certainly cited to you a lot of advocacy, but I think this quote should weigh extremely heavily on your ballot because it's from the Supreme Court of the United States in the case of United States versus Booker. And it's the Supreme Court making one thing clear, quote, we have never doubted the authority of a judge to exercise broad discretion in imposing a sentence within a statutory range. For when a trial judge exercises his discretion to select a specific sentence within a defined range, the defendant has no right to a jury determination of the facts that the judge deems relevant. When we dig under the layers, we see that acquitted conduct sentencing is a lot more complex and that it is a necessary tool for justice. We must allow judges to make these right decisions on how to best pursue justice. Thanks.
All right, that was a great speech. I have a 3-minute cross-examination for it. If you're ready. All right, I'll go ahead and start a timer. Great speech, Luke. Congratulations to making it for finals. So my first question for you. If there was a piece of legislation that made 30 people be imposed into slavery, should we end that policy?
This is irrelevant. Acquitted conduct sentencing has nothing to do with slavery. I think that's an unfair comparison.
So let's just say it's a bad policy. There's something that's extremely bad, extremely heinous, but it only affects a small amount of people. Let's say 30. Do we end it?
Of course, we should end slavery, but that's not a fair comparison for the course of this.
All right. Would you say being in prison for something that you were found not guilty of by a constitutional jury, is that a bad thing? Being in jail for something you were proven not to do, at least beyond a reasonable doubt?
Well, two things. First of all, these people aren't being punished for they're not being punished for that crime in particular. They're being punished for the crime that they are convicted of. That was the reasoning of United States versus Watts.
You'd agree that's the technical sense, but in essence, they're being punished for the crime that they were proven not guilty of by the jury, right? That's the reason acquitted conduct.
Right, but I think we should be precise with our language here, because I get the rhetoric that y'all are using, but I think that's a little imprecise and misleading about what's actually happening here.
I want to talk a little bit about the burdens of proof, because you talked a little bit about that, about how the preponderance of evidence standard is perfectly fine, and judges use it all the time. So you'd agree, preponderance of evidence standard, that's what civil courts use, correct?
Sure.
All right, and you agree beyond a reasonable doubt is a criminal standard when the government's prosecution, criminal cases.
Beyond a reasonable doubt is the criminal standard for conviction. Preponderance of evidence is the criminal standard for sentencing.
Correct, and you'd agree that when we're sentencing someone for a conviction, it's being based off that beyond a reasonable doubt that was based off the conviction that you were given, correct?
To a certain extent, yes, but judges can also consider other facts not found by a jury based on a preponderance of evidence, pursuant to the Supreme Court's precedent. Yeah.
Right, and you'd agree relevant conduct, which you were talking about in your speech as being that you don't have to find out beyond a reasonable doubt. That's something that has never gone for the jury. The jury never found that to not exist, correct? Relevant conduct.
Relevant conduct does include things like acquitted conduct that have gone before a jury, but it also includes things like uncharged conduct as well, sure.
Interesting. You have evidence to say that they're the same thing related in acquitted conduct?
Relevant conduct is just the umbrella term, and then you have uncharged and acquitted and dismissed underneath that.
So you talked a little bit how the statutory guidelines work only go up to 40 years. First, can I have the evidence for that? And second, people have been sentenced with acquitted conduct sentencing up to life, correct? We brought up evidence for that. How is that possible if you're arguing that it's only 40 years as a cap?
I'm not saying every criminal punishment is 40 years. I was just citing from what I know if you smuggle, for example, 10 grams of crack. But the reason why it would get up to life is if someone's, for example, robbed a bank and maybe the statutory punishment was 30 years to life.
Right. So my final question for you, you agree the Constitution only guarantees the existence of a jury, not necessarily that the result has to be followed?
You have a right to trial by jury.
Right. Okay, cool. Thank you for your answers.
All right, we'll go ahead and take our remaining 4 minutes of prep time. All right, we have 1 minute and 57 seconds remaining. There's a reason acquitted conduct sentencing was instituted. There's a reason the fence is there, and I want to walk through 4 main reasons as to why we should stick with the status quo rather than going with a dubious and potentially risky affirmative policy. I want to walk through that, not getting into all of the legal weeds, but actually going through the logic that the affirmative team has provided you today and why that doesn't stand. Let's start with the first overall point. You can write this down as not mandatory. Now, the affirmative team tries to walk this tightrope of saying that, well, technically it is advisory to use acquitted conduct sentencing, but also it's mandatory because of the way appellate courts enforce it. I take issue with that because if we actually look at their evidence, the evidence they pass back for the claim that appellate courts somehow make this mandatory, it really doesn't cut proving it entirely. It was one piece of evidence from 2008 talking about one appellate court who has held this routinely. That's not all of the other district courts in America. So this is by no means the rule, it's rather the exception to the rule. And we can see that far and wide, it is advisory for judges to use this, which begs the question, why are they using it? It's because it's necessary. Now, the affirmative team also got up here in the previous speech, and they tried to clarify the numbers issue. They said that, well, the statistic we gave was from citing the court case of the United States versus Watts. It's probably a lot more than that. I have 2 responses. First, only dealt with acquitted conduct sentencing. The main question of the court case United States versus Watts, if you actually read through it, is the fundamental crux of acquitted conduct sentencing on the issue of the Fifth Amendment. So it absolutely does deal with acquitted conduct sentencing. But secondly, there's no alternative quantification here. The affirmative team has never given you a solid percentage. They've given you hyperboles and they've given you what experts think, but they haven't given you actual numbers proving a problem. And if we go back to the burden, to prove a benefit, they have to prove a problem, and they simply haven't done that. Again, we need to remember, this is not a mandatory issue, and second, it's rarely used. Let's move on to my second overall point, and that is constitutionally upheld. Now, the affirmative team might take issue with this and say, well, we're not saying this is unconstitutional right now. But here's the thing, they're again walking that tightrope of saying, no, it's not unconstitutional, but if you actually take their argument to its logical conclusion, it's absolutely a constitutional issue. They're taking issue with the right to trial by jury and how the acquitted conduct sentencing might infringe on the effect of a jury's verdict. That's a constitutional issue. So let's look at what the Constitution enforcers actually say. That is the Supreme Court. Time and time again, they have pointed back to that court case of United States versus Watts and actually greenlit acquitted conduct sentencing. That's not because they're mean people and want to punish innocent civilians or people who weren't legitimately harmed or convicted, but it is because there's a reason why acquitted conduct sentencing is used, and that is to preserve actual justice. Let's move on to my third overall point. You can write this down as ordinary sentencing enhancement. Now, there's an important distinction to make with acquitted conduct sentencing, and that is, while the affirmative team says you're getting punished for something you weren't convicted of, technically, acquitted conduct sentencing is just a sentencing enhancement. So what happens if you're charged and convicted of one particular criminal charge is that a judge federally can use what's called relevant conduct. That has to do with either acquitted conduct, background, or character of the defendant. For all of those options, a preponderance of evidence is needed to apply that sentencing enhancement and make someone's time in prison longer. That's what judges do when they use acquitted conduct sentencing. And it's because it's necessary for that sentence to become more just. Think back to the example I gave you of Vincent Asaro, a longtime mobster, someone who had really caused a lot of problems with robbery, with multiple cases of murder and arson. He was clearly a criminal who should be in jail for a vast amount of time. Now compare that with the situation of someone else who is only convicted of one charge. Who should get the longer sentence? With acquitted conduct sentencing, the person who gets the longer sentence is Vincent Asaro because he deserves it. But if you take that tool away from judges, they're limited to the extent that they can actually achieve justice, leading to my fourth overall point. Important tool for justice. Let's go back to that cross-examination admission that the affirmative team gave in the first speech. Can juries ever be wrong? They basically admitted, rarely, but yes, it's possible for juries to be wrong. In those small instances we need to remember that acquitted conduct sentencing is an important tool that should be kept in the current system to better achieve justice. Thanks.
Alrighty. I'll go ahead and get my papers onto the podium. I'm gonna go ahead and get a timer for this 5-minute rebuttal. For clarity's sake, my name is Justice. I'm gonna be giving the speech. 5 minutes are on the timer. Right, everyone's ready? Wonderful. I'll go ahead and get started. The negative team told you one thing about our opener. They told you it was oversimplified. Well, in the words of the negative team, what happened was 3 men went into the woods, 2 came out. Here's what actually happened. 1 man, a police officer, went into the woods, according to our evidence. Then, the police officer's last words, as heard by a deputy, were, "It was a man with dreadlocks." And then a witness saw a man with dreadlocks leaving the scene. Well, there's one problem. Both Claiborne and Richardson, one had short hair and the other had cornrows. If that's a case that doesn't make sense, today is certainly an example of one. At the end of the day, the case of Claiborne and Richardson defines the affirmative position. If attorneys don't have evidence to prove your guilt, they shouldn't get a go-free card to get a lower standard of evidence at trial. If you agree with me that not guilty means not guilty, I'll be asking for your ballot. Let's go ahead and respond to all the arguments. I'd like to clarify that Anna's arguments do overlap with Luke's, so I'm going to be responding to Luke's and as a result responding to Anna's as well. Let's go ahead and get into that first argument. The first argument was basically the quantifiable issue. Essentially, the argument here is we can't quantify it, you should vote neg. And the reasoning is it's insignificant and it's only used in a rare amount of cases. Now, there are a couple problems with this. First off, let's go to the CX where I asked the negative team one question. I asked if justice is quantifiable. The answer was no. My response you can simply tag down is justice is inquantifiable. Once again, justice is inquantifiable. Inherently, by its nature, justice cannot be quantified. For the negative team to come up here and say, because it's used in this certain amount of time, we shouldn't vote for it is just absurd at the least. However, justice is what should be valued here as we're dealing with the criminal justice system. If you believe not guilty means not guilty, you're voting for the affirmative team based off justice. However, my second response is to Anna's argument. Anna's argument was referring to the entire 32-a-year card. My response to the 32-a-year card you can write down as, you don't need to cite Watts to use ACS. Once again, you don't need to cite Watts to use ACS. We've already agreed upon this point. My partner's analysis there was entirely dropped by Anna. This point still stands. You don't need to cite Watts to use ACS. The number could be much larger than the cases that cite Watts. The second argument was talking about sentencing enhancements. I'm going to be responding to both the Supreme Court approval and the argument of the preponderance of evidence right here for clarity's sake. The argument here was twofold. The first argument here was they already used the preponderance of evidence standard at, in sentencing enhancements, so it's totally fine. And the second argument was the Supreme Court has approved the statutory range, or the jury approves it, so it's okay. My response you can simply tag down as overlap in discretion is unjust. Once again, overlap in discretion is unjust. I entirely agree. Whenever judges make sentencing enhancements in the statutory range, that is technically legal and technically fine. We've already agreed upon this since the beginning of today's debate round. However, when that overlaps with a fact that a jury explicitly found, all of the evidence and advocacy in today's debate round point to one thing. Yes, that's legal. However, that is unjust and a bad policy. If the jury finds one thing, we shouldn't allow the judge to step right over that fact. So just because the preponderance of evidence standard is used in this case doesn't justify it because there is an overlap. However, my second response is to the argument the Supreme Court approving the statutory range. My response you can simply tag down is exceed statutory range. Once again, exceed statutory range. I point you to the evidence in my 1AC where it was literally talking about how if you are convicted of they treat this conduct as if you were convicted of a crime. That implies that it's basically adding on another crime onto your sentence. That's additional time beyond the statutory range. My third response to this argument you can write down as Supreme Court found legal. Once again, Supreme Court found legal. I point you to my 1AC. What did I tell you? I asked you one question. What should justice look like? Not what does justice look like, or what type of justice is legal. However, should it look like it does in the current system? If you believe not guilty means not guilty, you're voting affirmative regardless of whether the Supreme Court found that practice legal. The next argument was talking about how it's not required. My response you can simply tag down as legally factor in. Once again, must legally factor in. My evidence in the 1AC said they were required to use it. My partner then talked about how it's mandatory. We even provided a court case to the negative team in which an appellate court overturned a sentence because they didn't use acquitted conduct sentencing. However, I've got another piece of evidence for you, and just in case it's not convincing. According to Barry L. Johnson, writing for the Suffolk University Law Review, quote, any sentence representing a variance from the guidelines is subject to appellate review for reasonableness. In effect, if the sentencing judge fails to articulate an adequate justification for a sentence that falls outside the guidelines range, the appellate court must overturn that sentence, end quote. Guidelines are practically mandatory, meaning that they are required to use it. Next, they talked about how we must prove the proof of abuse. My response you can tag on is the existence. The existence of acquitted conduct sentencing, the denial of not guilty, is the abuse that's occurring. But finally, let's talk about the last argument. The last argument is this entire idea of judicial discretion. My partner already responded to that, telling you if you don't have evidence, you shouldn't bring it to court. However, my response you can tag down as the antithesis of judicial discretion. Once again, the antithesis of judicial discretion. We read a piece of evidence that found one thing. ACS being forced upon judges, once again, 84% of judges don't actually like it. ACS being forced upon judges is not judicial discretion. It is the antithesis of it. If you agree with me not guilty means not guilty, I'd ask for your ballot. Thank you.
I'll go ahead and start my prep time. All right, I'll go ahead and start my last speech. When we're making decisions about the United States criminal justice policy, we need to have a standard of rigor that's higher than just maybe making the world a better place. We need to actually see if there's a real quantifiable problem in the current system, a tangible, significant issue as is mandated by the resolution. And secondly, see whether their plan will actually certainly provide a tangible benefit over the current system. And in this speech, I want to demonstrate one final time that how in the affirmative team's zeal to pursue justice, they're doing the exact opposite. They're perverting justice because they're tearing down the offense of acquitted conduct sentencing without actually understanding why it's being used, how it's being used, and in the manner that it's being used, how it's being used to pursue justice. I have three reasons for this. My first voting issue is used to promote justice. Used to promote justice. How do we know this? There's a couple reasons. My first subpoint is only used when necessary. Only used when necessary. The only team in this round that's actually been able to provide you with quantifiable statistics about the use of acquitted conduct sentencing is the negative team. And we've proven to you that acquitted conduct sentencing is used in 0.04% of the cases. They argued that justice isn't quantifiable. However, our contention is that because it's used so rarely, it actually isn't unjust. In other words, it's used in those small minority of cases when the jury gets it wrong. They also argue that they don't necessarily need to cite Watts in order to use acquitted conduct sentencing. This is just objectively wrong. When courts create someone's sentences, they cite other court cases to help them create that sentence. When United States versus Watts is cited, that's why it's being cited for acquitted conduct sentencing. Furthermore, even if you have doubts about this, we're the only team that's actually provided you with a real number. Needless to say, based on the actual cold, hard statistics, acquitted conduct sentencing is rarely used, meaning that when it is used to promote justice. My second overall subpoint under this argument is not required to use. Not required to use. Justice in his last speech contended that judges are legally required to factor this in, and that it's the antithesis of judicial discretion. This is objectively false, pursuant to the United States court precedent in United States versus Booker, which we've all agreed made those guidelines, like acquitted conduct sentencing, completely advisory. Sure, they have to use it. They have to think about it. But that doesn't mean they actually have to use it in a meaningful, tangible way. And that's why the number of cases where acquitted conduct sentencing is so low. Here's the calculus that you have to make in this round. Who would we rather leave this to? We'd rather make a blanket policy, always banning this in every circumstance. Or would we rather leave this option open to educated and wise judges to be able to use this as a tool to pursue justice? I think the latter is the better option. Let's look at my second main voting issue, which is jury verdicts are respected. Jury verdicts are respected. That's what you get when you vote for the current system. They argue that overlap in discretion is unjust and that judges shouldn't be able to sentence someone for a crime that they're not guilty of. Actually, the Supreme Court disagrees. That's my response. The Supreme Court disagrees. This idea that judges have complete discretion within the statutory range authorized by jury is something that is wholly confounded and moored to the Supreme Court's precedent and our common law. As the court wrote in United States versus Booker, we have never doubted the judge's authority to use acquitted, or to not necessarily use acquitted conduct, but in that case, to use relevant conduct in crafting a defendant's sentence within the statutory range. The Supreme Court disagrees with the affirmative team here, and it's clear to see why. I want to get into my third and final voting issue, which is eliminating a necessary tool for justice. Eliminating a necessary tool for justice. And I want to bring us back to those examples that we have provided you in this round. When you look at people like Vincent Asaro, people who are clearly criminal mob bosses, he was a notorious mob boss in New York City. There's a reason why we used acquitted conduct sentencing in that case. And when opining on that case, I want to bring us back to the card of evidence that we read from the United Nations, which I want to clarify because there was some disgruntlement about this card. Here's what it actually says, quote, due to the difficulties authorities face in relation to investigating and prosecuting organized crime, the possibility of considering acquitted conduct as aggravating factors can be an important tool in executing long-term prison sentences for members of organized criminal groups, end quote. This was not merely describing the practice, it was endorsing the practice, and for very good reasons. The United Nations knows a lot about pursuing international drug trafficking rings, and this is a very good reason why we have acquitted conduct sentencing. Think of it like this. You have two individuals. One of them is Vincent Asaro, who's convicted of arson and also more likely than not, based on a preponderance of evidence, has committed murders. You have another individual who's only convicted of arson. Which person should get a higher sentence? I would argue that for the sake of justice, for the sake of public safety, people like Mr. Asaro must and should get a slightly higher sentence using acquitted conduct sentencing.
The former team is going to go ahead and start prep time at 2 minutes and 20 seconds. And just to confirm, the card regarding the UN, is that the card you sent us regarding them citing the case? Is that the one you're talking about?
That's the one I previously sent, yes.
Okay, is that the one that Luke just used, just really quick?
Sorry?
Is that the one Luke just used?
Yes, it is.
Yes, it is. The part that I read was the last part in that card.
All right, my preparation time has expired. This is a 5-minute speech. 5 minutes in that timer. If everyone's ready, I'll go ahead and start that timer. Rachel Barco, a professor of law before the United States Sentencing Commission in 2009, said, quote, "Acquitted conduct may no longer violate the Constitution in fact, but it does so in spirit. It disrespects the jury's function and verdict," unquote. Because the affirmative team agrees that acquitted conduct sentencing is not just a bad policy, but it's an injustice, we're asking for your ballot. In today's speech, I'm going to go ahead and respond to all of those main three central ideas the negative team brought up before I dive into three main voting issues of my own. Ultimately, why the affirmative team will provide a net benefit. Before I go into that, he did talk a little bit about, of course, what the affirmative team needs to do to win your ballot. The affirmative team would say that, well, we need to obviously present a benefit. We need to provide an effective advantage over the current system. We need to show that there's some amount of problem in the status quo, and we need to at least help that problem get better. That's our burden. Let's dive into the voting issues. The first was it's used to promote justice. It's used to promote justice. You can tag my response as used to pervert justice. Used to pervert justice. The opening story that my brother talked about, people coming out of the woods, and these people that were actually sentenced did not even match the basic facts of the case. The person that committed the murder had dreadlocks. The people coming out had nothing like dreadlocks, yet they were still sentenced as though they were guilty of that murder. These people did not do it. There was no evidence to actually support that fact because, well, they didn't even match the basic description as the evidence stated, thus they were sentenced. It's used to pervert justice and thus should end. Her next point was that it was 0.04%. You can tag my response as it's skewed analytics. We've already talked about this. These analytics are skewed. He said basically that of course they're going to cite Watts in every single one of these cases. Well, they don't have to cite Watts. They could cite any other case in the past that used acquitted conduct sentencing, not necessarily Watts. They could use the case that happened a year ago that also used acquitted conduct sentencing. You don't have to cite Watts in order to use acquitted conduct sentencing. It's not required, nor has the negative team brought up any evidence to support that fact. He talked about how juries get it wrong. You can tag my response as should never overturn a jury. Should never overturn a jury. The judge could, in that case, hypothetically say the jury is always wrong. Does that mean that we should always give a safeguard just so if the jury does get it wrong, then the judge can overturn it? If that's true, then the judge can hypothetically always overturn the jury. That's the whole point. That's why acquitted conduct sentencing is so bad. That's why almost every single advocacy group, political advocacy group, criminal justice advocacy group believes that acquitted conduct sentencing should end. We should not give judge this kind of power. His next point was, of course, about how we always cites Watt. I've already responded to this. Other cases don't have to use Watts. They can use anything else. His next point was that Brooker basically makes acquitted conduct sentencing not mandatory. Both in the past, acquitted conduct sentencing is not mandatory, meaning that judges don't actually have to use it, but also that our plan won't be mandatory if we were to pass it. I've got a couple of responses. The first response is if used, overturned. Once again, if used, overturned. Burial, he knows a lot about criminal defense because he does happen to be an attorney and he knows how it is. If you go outside of the guidelines, your case will be overturned. And he also wrote, the same person, Burial from the Suffolk University Law Review, also said that ending acquitted conduct sentencing through Congress, well, it would work. He literally even said even in a non-mandatory or advisory system, it would still work. It would still solve. And my other response is it solves prospectively. Not only did this criminal defense attorney say that it would work, our policy, ending at congressional enactment, the American Bar Association, which does know a thing or two about legal guidelines and stuff like that, also said it would solve the issue prospectively. A congressional enactment, which is what the affirmative team is doing. If someone goes outside of these guidelines, your case will be overturned. That was found conclusively with evidence, and negative team has not had evidence to go against that. His next was about how verdicts are respected, and this was about how the constitutional is the determiner of whether or not verdicts are disrespected. You can tag my response as Constitution only guarantees a jury. They don't actually guarantee the effect of that jury's verdict. What we're saying is that right now acquitted conduct sentencing is disrespecting the verdict of that jury because the judge doesn't have to follow that jury's verdict. All they have to say is, well, as long as you have a jury trial, we don't have to do it. That was the opening quote that I said. Your verdict is interesting, jury, but we don't have to follow it. That is the problem. Which going on to his last example of it being a necessary tool. He brought up how there was one example of the example that they brought up. You can tell the response as one example versus all the groups. We brought up multiple pieces of evidence of it being used pervertly, including the opening example, but also all the political advocacy that says acquitted conduct sentencing is a bad idea. The final argument was of the UN. You can tell the response as it's never endorsed. Never endorsed. The literal quote is them quoting a court case. This is just them quoting the holding of the court, not that they actually endorse it. My first voting issue is that of significant injustice. This is happening tens of thousands of years of being added. They're trying to make it seem like a little thing. This is a big thing. It's a big problem that people are being sentenced when a jury said that they didn't do it beyond a reasonable doubt. This is guaranteed from the Constitution. The second voting issue is solved prospectively. The uncontested evidence says that if you pass the affirmative team, a congressional enactment, you will solve the issue prospectively, which leads to the advantage that if I third voting issue of ending injustice. If you believe that not guilty means not guilty, the affirmative team is the only way to go. If you believe that respecting the jury is what you need to do, you should vote for affirmative. Thank you.
Great round, everyone. That was a lot of fun.
Great job to the affirmative team, and thank you so much for all of your time judging.
Yes, thank you so much, all of our judges. That was a really fun round.
Thank you guys for making this possible, and great job, Justice and Cyrus.
Yeah,
Great job. Great job to both teams, and thank you again, Tyler and David, for judging. We're going to get those ballots worked on. We have turned off ballot access at the moment for finals, just so that award ceremony will be a little bit more of a traditional surprise. But you will get those tomorrow at 8:30 p.m. Central Time when we have awards. So thanks so much, and everyone have a great night.
Good night. Have a nice day.